I'm Nikki Jovicic from LookUpStrata, and for today's webinar session, I'm joined by Bryan Thomas from Building Appeals Board. Please excuse the quality of the recording of this webinar. We experienced some technical difficulties and the quality is not up to our usual standards. However, the information shared by Bryan is highly valuable. Bryan's joining us today to inform you of the role the Building Appeals Board plays and how they may be able to assist if you have a cladding problem in your building. Who is the Buildings Appeal Board? What role do they play and how do they operate? Bryan is here to explain who the BAB board members are, what authority they hold, and the types of appeals or disputes they hear. Of course, the focus of this session is how the BAB can assist strata buildings in Victoria in remediating the serious defects of cladding, and Bryan's going to step us through the process. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in the session. Welcome, Bryan, and thanks for joining us today. After completing national service in 2072, Bryan commenced his legal career in private practice. Until 2014, he practiced primarily as a building and construction and owners corporation lawyer. In 2003, he graduated from Melbourne University with a master's degree in construction law. In 2014, Bryan was appointed a sessional member at the Victorian Civil and Administrative Tribunal, sitting primarily in the building and property, owners corporation and civil claims lists, retiring from VCAT in July 2021. He's been a legal member of the Building Appeals Board since 2005, recently chairing panel hearings applications relating to the replacement of combustible cladding on the exterior of buildings. Welcome, Bryan. It's a pleasure to have you with us today, and thanks so much for joining us.
Thank you, Nikki. Good morning, everybody. The Building Appeals Board is an independent statutory body established under the Building Act 1993. The board makes decisions about matters relating to the building regulations, the Building Code of Australia, and sections of the Building Act. The board hears appeals, disputes, and requests for modifications and compliance assessments on a weekly basis, usually sitting in panels of 2 or 3 members. Panels are made up of professionals from across the building industry, and members are chosen are based on the nature of the matter before the board and the expertise required. Board members include project managers, builders, building surveyors, fire safety engineers, quantity surveyors, structural and services engineers, access consultants, architects, town planners, construction lawyers, and consumer experts. So you can see there's a broad church of experience in the board. The board's authority includes appeals and disputes under Part 10 of the Building Act, modifications to regulations that should not apply to a building or apply with a variation, and modifications to the building regulations relating to access for persons with disabilities. Examples of matters that are heard by the board are appeals from building and occupancy permits, decisions of councils regarding siting matters, building notices and orders, directions to fix defective or non-compliant building work, determinations as to the appropriateness of protection work, secondly, disputes relating to protection work and ancillary steps leading to the carrying out of protection work, the building permit levy, the application of the building regulations, and the construction of party walls. Thirdly, applications for compensation in connection with protection work. Fourthly, applications that a provision of the building regulations does not apply to a building or protection work or applies with modifications or variations. And finally, applications that a particular design of a building or an element of a building complies with the Building Act, the building regulations, the Building Code of Australia, or the relevant Australian standard, which is relevant to applications for alternative solutions for the total removal and or replacement of external combustible cladding. Now, the board also conducts site inspections, which particularly with respect to cladding applications, it invariably decides that such as an inspection is appropriate. Then a written determination with accompanying reasons is issued to all parties once the board has made its decision. Hearings are informal. They are typically held on Thursday mornings and are normally open to the public, but unfortunately, since the advent of COVID, hearings have been conducted remotely. Now, more recently, I have chaired panels hearing applications relating to the replacement of combustible cladding on the exterior of buildings. The most typical of cladding applications that I see is in relation to aluminium composite panels, or ACP. And this is a material that has an external and interior aluminium panel, and in between the panels is a material which is unfortunately highly inflammable. Now, the Building Code of Australia requires that the external walls of a building must be non-combustible. As a result of the fires in the Lacrosse building, in Docklands, and the building in Spencer Street, also, of course, following the tragic Grenfell fire in London, the Victorian Building Authority conducts audits of buildings across Victoria that are more than 3 stories in height and which have external combustible cladding. Now, the VBA generally considers that all combustible cladding should be replaced by non-combustible cladding, and communicates this opinion in respect of a particular building audited to the municipal building surveyor of the municipality in which the building is located. The MBS then typically issues a building notice to the building owner stating that the installation of combustible cladding was in contravention of the building regulations or the Building Code of Australia, the BCA, and the building is considered to be a danger to the life, safety or health of the occupants of the building or any member of the public. And the notice requires the building owner to show cause why the combustible cladding should not be replaced. Now, if the building owner fails to comply with the building notice, or the MBS does not accept the owner's justification for retention of the combustible cladding, the MBS will then issue a building order requiring the building owner to remove the combustible cladding totally within 60 days. Now, depending on the height of the building, the cost of replacement of the combustible cladding can be prohibitively expensive. And unless the developer or the builder are still in existence, if an owner's corporation is the owner of the building, that cost must be borne, that cost of replacement of the combustible cladding must be borne by the lot owners. Now, Section 160 A of the Building Act allows a building owner to apply to the Building Appeals Board for a determination that an element of the building complies with the Building Act or the regulations. And in particular, the building owner may apply for a determination that the existing external combustible cladding complies with performance requirements CP2 and CP4 of the Building Code of Australia, and that partial removal of combustible cladding around high-risk areas in the exterior walls of the building, generally from the first 3 levels, around entrances, exits, windows and balconies, is an acceptable alternative to the total removal and replacement of cladding. Now, performance requirement CP2 concerns the spread of fire and lists the elements of a building that, to the degree necessary, avoid the spread of fire. Performance requirement CP4 concerns safe conditions for the evacuation of a building in the event of fire, and must, to the degree necessary, resist the spread of fire and limit the generation of smoke, heat and toxic gases. Now, such an application to the board needs to be supported by a report authored by a registered fire safety engineer. And the report must address how the proposed alternative solution to total removal and replacement of combustible cladding will comply with performance requirements CP2 and CP4. An application to the board pursuant to section 160A lists the building owner as the applicant, the municipal building surveyor as an interested party. Once the application is filed with the BAB registry, directions and orders for the future conduct of the proceeding will be made within 2 weeks. But in more complex matters, a directions hearing will be convened by the chairperson of the board. Now, having considered the documentation filed in support of the application, either on the papers or at a directions hearing, the chairperson will firstly confirm the issues for determination by the board. Secondly, determine who are the persons concerned that should be added as interested parties to the application. And they are entities that have a direct and immediate interest in the outcome of the proceeding. And that is generally, they are generally the Victorian Building Authority and the Fire Rescue Commissioner. Thirdly, the chairperson will direct that the applicant file with the board and serve on the respondent and the interested parties a document entitled a Statement of Contentions. And that document sets out the basis of the owner's application under section 160A with appropriate references to the report of the fire engineer. The respondent and the interested parties will be directed to serve and file and serve statements of contentions in reply to that of the applicant. And finally, the application is listed for hearing, on a date 6 to 7 weeks from the date of the issue of the board's directions. In more complex proceedings, in order for the parties to properly file and prepare for the hearing, an additional time may be provided. Now, the panel hearing the application will comprise a chairperson, usually a lawyer, a fire safety engineer, and a building surveyor. The panel will firstly clarify any necessarily preliminary matters and then hear evidence from the parties and their witnesses, particularly in the case of the applicant building owner, the author of the fire safety engineering report. The panel members may have questions of the parties or their witnesses, and the parties may also ask questions of the witnesses. The parties are invited to make final submissions in support of or in opposition to the relief sought in the application. Now, the board is not bound by the rules of evidence as in a court, but is bound by the rules of natural justice, which requires the panel to afford all parties before it procedural fairness. If following the conclusion of the hearing, the panel requires further clarification of issues raised, directions and orders requesting the filing and serving of additional information or documentation will be issued to the parties. The board's determination as to the outcome of the application will be issued to the parties approximately 6 weeks from the hearing or compliance with any directions and orders subsequently issued by the board. The determination will either approve or reject the alternative solution proposed by the applicant building owner to total removal and replacement of combustible cladding, or approve the application subject to conditions. If the board approves the application with or without conditions, a time frame for the carrying out of the building works approved by the board or a completion date will be specified in the determination. The board's determinations are final and must be complied with and put into effect by all parties. A determination of the board can only be appealed to the Supreme Court and on a point of law. After the board has issued its determination, the parties are at liberty to seek an order for costs against another party to the proceeding. However, as in VCAT, the Victorian Civil and Administrative Tribunal, the board is a no-costs jurisdiction, and Schedule 3 to the Building Act provides that each party must bear its own costs unless the board considers that an order for costs in favour of one party against another party is justified. Now, the board has a number of practice notes to assist parties in preparing and conducting proceedings before the board. In relation to Section 160A applications, the following practice notes are relevant. PN1, applications for modifications and compliance assessments. PN5, expert evidence. And particularly PN7, proceedings concerning combustible external wall materials. Now, these practice notes can be accessed on the board's website, and that will be stated in the material, the presentation that you'll receive. Finally, it needs to be appreciated that such an application to the board is a special application and needs to be supported by appropriate expert evidence from a fire safety engineer. An application to the board which does not contain that expert evidence will be doomed to fail. So in conclusion, I've endeavoured to explain to you the relatively simple, speedy and inexpensive procedure that the BAB provides for the approval of alternative solutions to the total removal and replacement of combustible cladding. Now, I trust that this presentation has been of assistance to you, and I'm happy to take questions. Thank you.
Thanks very much, Bryan. That was really interesting. I mean, it's given us an insight into something that we probably wouldn't be able to have normally. So thank you for stepping us through. I know there was a lot of information contained in that presentation, and that's why I think it's great that we're providing the recording of it so people can watch it again and again and pick up certain points during the presentation if they've missed things while you were speaking, because there's quite a lot of information there. I mentioned just in the chat, we're sending out the recording later today, and we'll also include a link to Bryan's notes on this session too. So you'll have some material that will accompany the presentation, and things like Bryan's mentioned, the practice notes that are available. We'll place the links in that material as well, so that you can access those practice notes and have a look at those at the same time. So we've just we've got a few questions that had come in from the audience, which is great. Thank you very much for sending those in, and we'll cover those. And then I've just gone through and pulled out a few questions that I thought, even though it was mentioned during the presentation that Bryan's just given, it might be useful for you to hear sort of just a few of the points pulled out separately, so that we can have a bit of a discussion about those. So what we might do now, Bryan, if you're ready and you're right to go, we might jump into one of the questions that's been submitted to us.
Yes, certainly.
Excellent. Okay, so the first one we received in, this one's from Janet, saying, given the ordinarily installed cladding was approved, given the originally installed cladding was approved and signed off by the council building surveyor, why is it now up to the owners to foot the rectification bill when the apartment block is deemed low risk? The state government should pay for all cladding rectification irrespective of risk level.
Well, that question raises a number of issues. Firstly, I query whether the municipal building surveyor would have been involved in approving the initially installed cladding. The building permit for the construction of the building would have been issued by a private building surveyor, and that permit would not have been issued until the building surveyor had been provided with detailed plans of the building, including proposed materials. The second point is that combustible cladding in its various forms was only made unlawful as a result of the fires. Prior to that decision, various forms of combustible cladding were given a certificate of approval by an independent testing organisation. Now, the result, or as we sit here today, all combustible cladding in whatever form is considered to be unlawful. So it's not a matter of whether owners have a claim against third parties, whether it be a building surveyor, a builder, a developer, for installing unlawful cladding. The fact of the matter is that as far as the government is concerned, this is a problem that has to be rectified by the owner of the building. And as I said in my presentation, if the developer or the builder are no longer in existence, well then the building owner does not have any recourse against them, and therefore the building owner is liable to for the removal and replacement of the combustible cladding. There is an organisation set up by the government called Cladding Safety Victoria, to which application can be made for financial assistance to meet the cost of removal and replacement of combustible cladding, either in total or pursuant to a determination of the Building Appeals Board. I trust that that adequately answers that question.
Excellent, thank you. Okay, Brian, we had another one that came in, and this one was from Marshall, and he asked, if our strata has already taken out a commercial loan for investigation of the type of cladding and proceeded with replacement of the cladding, can we refinance the loan with the Victoria government scheme at a lower concessional rate?
Well, I'm afraid I don't know the answer to that question. The board has little to do with Cladding Safety Victoria, and I could only suggest that you submit an application to CSV and they may or may not accept it on the basis that you already have commercial finance in place.
Okay, thank you. And we might see if we can get an answer for Marshall on that one as well. But thank you for your input there. Okay, we did have two questions come in while we were chatting, and I'm sorry I haven't had a chance to read over them yet, but I might just go through them and see if you can assist with these ones, Brian. So we had a question that came in from Paul saying we have a situation where we had a tenanted property with a large balcony on the 5th level of a high-rise apartment building. This large balcony has been occupied almost totally by a cladding removal company authorised by the Owners Corporation to remove cladding from the upper 13 stories of the building. It has caused huge inconvenience to our tenants who have threatened vacating unless they get a substantial rent reduction. If we give this rent reduction, can we ask the OC to reduce its fees by the same amount? That's probably more an Owners Corporation question.
Yes, that's correct. And if the Owners Corporation was not prepared to grant concession to the lot owner, then the lot owner would be entitled to file an application in the Owners Corporation listed VCAT seeking a reimbursement or an appropriate adjustment of the levy.
Okay, so a little bit out of scope of today, but thank you very much for the input there, and that gives Paul a bit of direction as well, which is great. So thank you for that. And the other question that we had submitted during your presentation was one from Nick saying, I'm in a high-rise building of 60 plus levels with ACP that was deemed by the VBA as moderate risk, therefore not receiving government support for rectifications. Can the risk assessment change to high risk if it was found that the BAB inspectors missed large amounts of cladding that wasn't identified in their inspection report to designate a moderate risk level, therefore not meeting the threshold for government support?
The answer to the question is yes, but it would be necessary to engage a fire engineer to conduct an inspection and make a determination as to whether the risk is in fact moderate and not low.
So that comes back to that evidence that you were speaking about during your presentation.
Yes.
Okay, all right, now we might move on. We had a few other questions, as we mentioned. If anyone else that's sitting in the session at the moment has something that they'd like to ask, it's a really great opportunity for you to speak to somebody with the knowledge that Brian has. So we've just had something from Paul come in saying, what is the cost of making an application to the BAB? Unsuccessfully, can you recover the costs, including the costs of engaging a fire safety engineer?
There's a filing fee payable on the application. I think it's in the vicinity of $350. Now, the other part of the question relates to costs. If the building owner is successful in its 160A application to the board, as I explained, it is possible for an application for costs to be made, which would include reimbursement of the filing fee. But as I said in the Building Appeals Board, the costs don't follow the event as in a court, and the mere fact that a building owner has been successful in its application doesn't mean that it will automatically receive a costs order in its favour against the VBA or the Fire Services Commissioner or any other party that is joined to the proceeding by the board.
Okay, thanks, Bryan, for that. And I think we just had a question come in from Joshua. It's a little off topic, he says, so I'm not sure if this is relevant or not. Recently, we had a strata scheme builder go under, and we've had a large number of defects. We understand they fall to strata to repair. However, is there any route to compensation from the builder's administrator?
Well, that is a matter that would appropriately be heard by VCAT in the building list, but before proceedings can be instituted in VCAT against the builder or the administrator of the building company, it is necessary to file an application with Domestic Building Resolution of Victoria, which is a government institution which endeavours to solve building disputes involving defective, incomplete or non-compliant work by way of conciliation. And that process has to be followed through, and if a settlement is unable to be reached at conciliation, or the builder refuses to carry out rectification work that is the subject of agreement at the conciliation, it is only then that the next step of filing an application against the builder in VCAT can take place.
Okay, hopefully that's helped, Joshua. And then Leanne has asked, there has been a change in government funding available. Government funding is only available for those buildings that are a high or extreme risk. And even if a high risk, it is dependent on a number of factors. I've one building that was entered into the CSV program at a high risk and then removed once further assessed by the VBA board.
I'm sorry, I'm not sure what the question is.
I'm not sure either. Maybe Leanne's just letting us know that that was happening. Did you want to comment on that at all, or you're happy?
Well, it's something that I'm not aware of.
Okay, that's fine. Sorry, I'm not reading these. I'm reading them as they out to you as they come in. And then Jimmy has asked, thank you, Bryan. Have you seen many cases whereby a fire engineer has recommended retention of ACP or EPS, but the council surveyor has refused to accept the recommendation?
No, I'm not aware of that, those instances, because if in response to a building notice issued by the municipal building surveyor, the building owner engages a fire safety engineer to prepare a report justifying retention of the combustible cladding, well, that then is provided to the building surveyor, who accepts or rejects that report. And then if the report is rejected, issues a building notice. Now, it's at that stage, then the building owner has to decide whether to appeal the building order by way of an application to the board. And of course, the fire engineer's report would be considered by the board in making its determination. but more than likely the fire engineer would be required to provide a supplementary report, particularly addressing the reasons that the building surveyor has given for refusing to accept the report.
Okay, thank you for that. Hopefully that helps Jimmy as well. Now we might just, I pulled a few questions out just to go over a few points and for some clarification. So we might just jump to those until we have any more questions that come in from the chat. So one of the things I'd written down to talk to you about, Bryan, was what should the committee have done prior to contacting the BAB, and at what steps should the BAB become involved? And can you explain how important timing is?
Well, there are some building owners who have been proactive and have engaged a fire engineer to conduct an inspection and provide a report as to what combustible cladding should be removed and what should be retained without the VBA or the municipal building surveyor being engaged. But more often than not, it's not until a building owner is served with a building notice that the concern becomes apparent. And in that situation, I would strongly recommend that the building owner engages at that stage, at that early stage, an engineer to conduct an inspection and provide a report. Of course, if a building order is served and the building owner wishes to appeal that order to the Building Appeals Board, as I've explained, a report from a registered fire engineer is essential.
Sorry, Bryan, I'm just in chat at the same time as I'm mediating. Okay, so thank you very much for that. And then another question that we had, probably just relating to that, is do you have any up-to-date numbers on how many buildings still require cladding removal? Are all building owners aware if they may be subject to an order?
The simple answer is no. For reasons known better to itself, the VBA is somewhat secretive in deciding on which buildings should be audited, and the outcome of those audits. The board is not provided with any of that data.
Okay, thank you for clarifying that. And we also had another question. Is there a percentage of the building that needs to be unaffected, or any other circumstances where cladding is not required to be removed? I know you did cover this quickly during the presentation, but if you could just give us a little bit more clarification there.
Sorry, I didn't quite follow what the question was.
Is there a percentage of the building that needs to be unaffected, or any other circumstances where cladding is not required to be removed?
Well, it's not addressed in terms of the percentage of area of combustible cladding that needs to be removed. The starting point is removal of combustible cladding in high-risk areas. And as I explained in my presentation, that generally is from the first 3 levels, around entrances and exits, around windows and balconies. Now, depending on the particular building, there may be other areas of where there is combustible cladding that the fire engineer considers should also be removed, or the board, once it's heard the building owner's application, decides should be removed in addition to those particular areas that I've highlighted.
Okay, thank you for that. And we've just had a question come in. This one's from Justine, and she's saying back in 2019, our building was given a building notice from council and a subsequent inspection of cladding from panel. To date, we are still waiting on instructions. Is it normal to take such a long time?
Well, I'm surprised that having a building notice having been issued and responded to by the building owner, that the municipal building surveyor has not yet indicated whether the explanation provided in response to the notice is acceptable or not. I suppose for the purpose of finality, it's appropriate that the manager, the OC manager or the committee requests a decision from the municipal building surveyor whether the response to the notice is acceptable or whether a building order will be issued.
Okay, thank you. And also, can the BAB similarly assist building experiencing water ingress issues or other serious defects? And if so, how?
The answer to that question is no. That is a matter that is appropriately determined in VCAP after the conciliation process in the DBRDV that I've explained is concluded.
Okay, and any building that has are there any buildings out there that possibly still have cladding and they haven't received an order and they're not aware that they have an issue with the building, or is everyone that has an issue been notified by now?
Well, I can't answer that. That's in the VBA's province, and as I've said, they're somewhat secretive as to where they're at with their audit and how many buildings have been audited and how many buildings are yet to be audited.
Okay, so there might still be some buildings out there that aren't aware that they have an issue.
Yes, quite possibly.
Okay, all right, so we're just calling now for questions again. You've got a situation where Bryan's in here and he's ready to answer questions. So if you have something that you'd like to get clarification on, or you have a situation, if you can jump in there and just type it in, and we'll get Bryan to answer that question for you. Bryan, are there any case studies that you can make us aware of, or some situations that you'd like to let our listeners know about that that have happened that might assist them?
Well, there are determinations of the board with respect to combustible cladding are on the Austlii website. 2 years ago, the Austlii started to record on its website BAB decisions, not all the determinations that are made, but determinations which are considered have some relevance. So if you went on to the Austlii website, to the BAB area, then you could go through those determinations that have been published, and particularly with respect to Section 160A applications, that might provide some assistance or enlightenment as to what is required.
Okay, that's great. Well, I might have a look and see if I can pull up the link to that as well, and I'll send that out to everyone when we send the email out later today. And that might be of assistance. There might be a bit of reading there that you can do that will help you moving forward if you're in that situation.
Thanks for joining us for this educational session. If you gained value from the information, please like this video. You can also engage further with LookUpStrata by subscribing to our YouTube channel, or by being kept informed about Strata news via our regular newsletters. Our subscribe link is listed in the description box below.